Welcome everyone to TPN Studio. So excited to have in studio with me this morning both Silna Stain from SSLR Incorporated, our drafting attorneys on our lease pack and our sales pack, and of course our head of legal, Peter Menon, because what are we talking about today? We're talking about evictions in a pandemic. And the reason we're talking about evictions in a pandemic is because we've looked at our latest squat data. And what is our squat data? Well, the TPN squat data looks at how many tenants are a minimum of 4 months in arrears with their rent. The reason that we look at a minimum of 4 months in arrears with their rent is because on average, an eviction should take you between 2 to 4 months. Of course, now that we're in a pandemic, we've seen that the evictions are starting to take a little bit longer. And it's not because the courts aren't giving you your evictions. It's because you have to wait for a court date, and then the court is a little bit more lenient on the tenants in terms of the date that the tenant has to vacate once they grant that eviction order. So let's look at the squat data. What is the squat data telling us? Well, prior to the pandemic, our squats were taking us, this is this blue range over here, between 0.6 and 0.8 of our tenants were in the squat position, a minimum of 4 months in a row with their rent. And you know, some tenants can get all the way to 18 months before that eviction is processed. We enter the hard lockdown, and that's where I've put these red bars in. And you'll see that the red bars in that first month of April got up to 0.6%. And then in May, it moved even higher to 0.8% of tenants that were in this minimum of 4 months in a row. As we exited and the release of those level lockdowns were granted in some relief, we saw that that number dropped again to 0.9%. As we entered the second wave, and now we're in the third wave, you can start to see that those numbers are escalating. We're back up to 1.6 of the number of tenants that are in that squat position. So in studio with me today, I'd like to welcome then, how do we process these evictions? How do we get them through the court system as quickly as possible? Can I please invite both Peter Menon, Head of Legal, and Silna Stain from SSLR Incorporated.
Good morning, guys.
Welcome,
it's so nice
guys.
to be with you. I'm so excited to be here.
Wonderful. And talking about evictions today.
Oh, it's your favorite topic, both of you, I know.
Always.
I know.
I thought it's my favorite topic.
Both, I think.
Before we get going, I'd just like to, as always, just remind everybody about the housekeeping or the house rules. So the first is, please do log into your YouTube channel, because once you're logged in, my job here is going to facilitate. So I'm going to be facilitating the questions and answers on the YouTube chat. And if we have questions and answers that are relevant at that point in time to what you're discussing, I'm just going to put my hand up and then I'm going to facilitate that you answer them. If we see that the questions are more general in nature, we're going to wait to the last 15 minutes.
Perfect.
Fantastic.
And you'll be taking those questions, and the feedback forms will then be provided to all our clients as well. Everybody that's joined us today, remember, go and fill those out. Not just important for our own feedback, but obviously for your unverified CPD points as well.
Absolutely, because our help desk will then be sending out your certificates based on those people that completed their feedback forms. And of course, if we do look blurry today in the session, please go to, there's a little cog on the bottom right-hand screen as being indicated now on the video. Click on the little cog, click on settings, and then change your quality to a minimum of 720. And you could even go up to 1500 if your video resolution allows you to.
And then while you're busy doing that, while you're at the bottom of your screen, please go and click the subscribe button, as well as ring that notifications bell, and then you'll get notified of any new upcoming training that we are doing from TPN Legal or from TPN side on the Credit Bureau system.
Wonderful, fantastic. Over to you two. Thanks, guys.
Thank you,
Thanks,
Michelle.
Michelle.
Silna, Michelle has now taken us through some invaluable information on squatting tenants. And let's just define what a squatting tenant is in terms of TPN scoring on the screen that we just had. That's a tenant that stays in a premises for 4 months or longer without making rental payments. So it's a tenant that's 4 months in arrears. Sure. Now let's step back from that, because the discussion that we're having today is about evictions, is about correct procedure, is about sending out the correct letters, the notifications to ensure that you have a successful eviction through the courts at the end of the day. Now, let's focus on the initial breach, because remember, the tenant is now 4 months in arrears in accordance with that squat score, but we've got to focus on the first breach of lease, the first time that the tenant does not make rental payments. So Silna, if a tenant does not make a rental payment on the due date, and I know you're going to take us through that today as well, what is the correct procedure? Do we need to send a letter of demand? What type of letter of demand do we need to send?
100%, Peter. And I think one of the biggest things is there is this perception that when a tenant doesn't pay rent, he is squatting. And I think you've made it very clear that is not the case. Actually, the truth is that, and you will obviously know this, but there isn't actually, the term squatting isn't actually a term that is used in our law. There's none of our acts or laws that contain the word squatting. It is a very handy way of describing a person that is in occupation of a premises that shouldn't actually be there for a certain period of time. So the truth is, how we deal with somebody that is not paying his rent, because he's not in illegal occupation yet. Remember, even though somebody is not paying rent, doesn't mean we can just kick him out or he's just a squatter. It means now we need to act. And the truth about this, and I think I'm going to bore you with this today a few times, I'm going to say act as quickly as possible. Now the truth is, when a tenant doesn't pay rent, the first thing you need to do is send a letter of demand. Until that is done, it can carry on, the situation can carry on with this tenant not paying rent until you actually act. It's not an automatic thing that happens in law when a tenant doesn't pay rent.
So that's such a great summary. So you need to place the tenant in breach. That's what we need to do. And that's what we're doing by sending out the initial or the letter of demand, as you've correctly indicated. Now, letters of demand get quite complex. They're nuanced. Because with rentals, you've got certain pieces of legislation that might apply in certain instances, and in other instances, they're not. And we're talking specifically about the Consumer Protection Act.
Yes.
So sending out the correct letter of demand is vital. And that's specific with the time period that you're giving the tenant to rectify or remedy the breach by sending that letter of demand. So there's different letters of demand that you can send. Which letter of demand do you send in which instance?
Brilliant. And this is a perfect question, because as Peter rightly said just now, if you get this wrong, it's not slightly wrong. If you use the incorrect letter or you do not use the correct legal terminology in your letter of demand, you can send a letter clearly communicating you haven't paid your rent, but it might not do the job. And if you do not do your letter of demand correctly, your entire eviction application will be fatally defective, meaning that 4 months down the line, when you are in court, the court can stand back and say, but listen, you haven't cancelled this agreement. You haven't placed the tenant in breach properly, and we can't grant the eviction order because of the first letter. Peter, can you imagine how sad you are 4 months later because of the wrong letter?
Yes.
Now, you asked me which letter should be sent. And the truth is, you need to make it very clear that the tenant is in breach of a term of the lease agreement. You need to tell the tenant, what are you doing wrong? Are you not paying your rent? Are you not complying with conduct rules in a body corporate situation? What are you doing wrong? And then you need to give them a clear time period that they have to remedy their breach. Now, this can be either in terms of legislation or in terms of your lease agreement. And this is crucial. And I'm quite sure you're going to take me through the entire process there.
Still, no, I think that's a great stopping point, sort of segue here, because we're talking about the letters of demand. You can send the 7-day letter of demand when the CPA is not applicable. That's obviously in accordance with your contract and the Rental Housing Act. And then when the Consumer Protection Act is applicable, Section 14, you need to send a 20 business day letter of demand. Now, what I see in practice very often is that clients communicate with the tenants over WhatsApp, or they send an email indicating that the tenant is now in breach, or just saying that you haven't made your rental payments. Now, a reminder is not a letter of demand, is it?
Not at all. And even a WhatsApp communication, for instance, saying, Mr. Tenant, you haven't paid your rent, you owe me, even if you say X amount of money, and you need to pay it within 20 business days. That is not a sufficient letter of demand. Your letter of demand has to comply in full, not just with legislation, not just with the Consumer Protection Act, for instance. It has to comply with our common law as well. Law of contract is a very technical field of law, and if you do not comply with the terms in terms of our law, then you have a fatally defective letter of demand, even though the communication is clear.
Now, I know Jade from our office is going to be very hard on me if I don't say this as well, but that's why sending out the correct letters of demand, specifically in terms of the National Credit Act for blacklisting, is so vitally important, because what you do with the letter of demand is, yes, you place the tenant in breach, but you also warn them of the consequences of non-payment. So let's move further into the consequences of non-payment, or rather consequences of not remedying the breach within the 7-day time period or the 20 business day time period. What can a landlord or an estate agent do in that instance when a letter of demand has been sent, the tenant has not paid within the time period granted?
Yes, so when that happens, once you reach the point where you're on day 21 or day 8 for that matter, you can cancel the agreement. You can cancel the lease agreement with a separate notice. You do a notice, just a letter. It's not a court document. It's nothing out of the ordinary. It's a letter that where you say you had this time period to remedy your breach, you didn't, and now the contract is cancelled. Once the contract is cancelled, now you have a tenant that's in illegal occupation.
So let's get this right. That's another formal communication we need to send to a tenant. It's not captured in the letter of demand. So we can't, in the letter of demand from the tenant and also cancel the lease agreement through an initial letter. That's what you're saying.
That's what I'm saying, and I've seen this quite a few times where people try to make life a little easier by sending a letter of demand saying that you've got 20 business days, that's compliant with Section 14 of the CPA and even with the lease agreement. But they then say in the letter of demand already that should you fail to remedy your breach, this contract will be automatically cancelled. Now that sounds like a brilliant plan, right?
Great idea.
You save time and paper, yay, the pandas will thank you. But the truth is that's not legally compliant. You need to send a separate cancellation, Peter, not just for compliance with law, but also practically in court. If we want to claim rent, up to the point of cancellation, what is due is rent. From the moment of cancellation going forward, it's damages, it's holding over damages. So if we can't show a clear point to the court where rent stopped being due and it's now holding over damages, it leaves us with a potential factual dispute, or even if it's not a factual dispute leading us into trial, which we'll get to definitely later, it will definitely cause confusion and delay your potential of obtaining a court order.
Michelle, do we have a question?
We have a couple of questions.
Yes, please.
So I thought let's start answering them as we go through. The first one is Nalini Pillay would like to know, will this be a documented process? Then can we get a copy of it? Peter, for you.
Fantastic question. Yes. Like Silna said, there's a lot on residential leasing that is captured in legislation. But the most important document that you need to focus on is the lease agreement, because that establishes the relationship between the landlord and the tenant. And it sets out these procedures. It sets out the procedure of sending out the letter of demand, when to send a letter of demand, when to cancel the contract. So in the TPN residential lease packs, I'll know if you don't mind the segue over here, is that we've obviously incorporated clauses into the contract that makes it simpler for a landlord or an estate agent or even the tenant in an instance to read through the contract and understand the process of cancellation, understand the process of sending a letter of demand. But the TPN lease contracts obviously flow and they follow that entire process through demand and cancellation.
Can I also say that you've got a created workflow document that sets it out?
Yes,
and I know SSLR definitely has one. So we will be sharing that with our delegates at the end. So please do, for our delegates, fill in those feedback forms and then we'll attach it as part of the documentation.
Thank you, Michelle.
And the certificate. Then I've had a question from Nadia, for you please, Sona. She's asking, if it's only a partial payment and it's in arrears for a year, is it still squatting?
That's a good question, Nadia. I'm very glad that you asked the question. It's not squatting. Remember, squatting is an index that TPN use to show how long a tenant has not been paying rent. When a tenant only pays partially, he's still in breach of the agreement. So what you need to do, well, could have done already the first day following a partial or non-payment, is to send a letter of demand. So my advice for you, free legal advice, look at that, thanks TPN, you guys are awesome. I would log on to the TPN system and I would pop out a TPN letter of demand like in now. Not now, just finish watching because this should be entertaining, but once you're done, send a TPN letter of demand on that tenant immediately.
Right, then I've got a question from Celeste, and she's asking, what can one do with a repeat offending tenant who waits for the letter of the demand and then pays every single month?
We just had a little wink between it ourselves, because we've got a clause in the contract that Silma's going to explain for us right now.
Yes, exactly. It's beautiful. Luckily, I have a copy of the lease agreement right in front of me. So what we've done in terms of our clause 22 of the TPN leaseback lease, we do cater for a situation where a tenant is in repeated breach. Clause 23 is the breach clause, where we deal with a tenant that's not paying rent or not complying with other provisions of the lease agreement. But what we've catered for in terms of the leaseback lease, because we see this quite often, is a tenant that repeatedly breached the agreement 3 consecutive months. I still recommend that you send a letter of demand once they have breached the agreement, but when they then keep on remedying the breach just in time, I do recommend that you send a specially worded letter of demand. That's actually a very good idea to then get to an attorney to draft that letter of demand to say the kind of breach that you are in is not non-payment of rent, it's constant late payment of rent. And then once he does that again, in terms of your lease agreement, clause 22, rate with 23, together with the correct letter of demand, you can still cancel that agreement even though he continuously remedies his breach.
Then we've got a question from Martin Porgita, and he's saying, please explain to the audience when the CPA is applicable and when it is not. So a little quick segue just so that we've got that in at top of mind.
I'm going to let the attorney handle this one. You do it so perfectly every time.
Like
so
you're not an attorney, but okay, let me take this. Actually, also, I do have a flow chart, Michelle, while we're talking about flow charts, which we are more than welcome to share. The first question that you ask, is this a fixed term agreement? So is it running from this date to that date? If the answer is yes, then you need to ask who are the parties. Section 14 of the CPA reads and says, this section will not apply to agreements concluded between juristic entities. So if either one of the parties, even the landlord,
yes,
Peter, is a natural person, Section 14 of the CPA will apply. So first question, is it a fixed term lease agreement? If it's month to month, Section 14 cannot apply. If it's a fixed term agreement and there's one natural person, so you in the name of Peter Menon is the landlord or the tenant, then Section 14 of the CPA will definitely apply.
And I think important there also, that's regardless of annual turnover or asset value, also on the juristic entity. So the 2 million threshold that you've got in the CPA is not going to be applicable when it comes to your Section 14 applicability, whether you're sending 7-day letters of demand or 20 business day letters of demand.
Very important to point that out. Thank you.
I've got 2 more questions in line with this.
Please.
I see there's lots more questions coming in, so I'm going to hold them over because some of them are more of the general nature and we'll be dealing with them later.
Perfect.
But these 2 do relate, one to CPA and letter of demands. So Annie Cornier is asking, do the courts accept the 7-day letter of demand for a non-fixed term lease, so that would be a non-CPA lease, or do they require a 20-day letter of demand like the one they used to some time ago?
So perhaps just having a look at that question, let's take it a little bit further and let's say the contract's on a month-to-month basis. Yes. Because then obviously the Section 14 of the CPA is not going to apply because we don't have that fixed term time period. So let's say the contract's on the month-to-month basis where a 7-day letter of demand can be sent.
Yes, very important. You can then send a letter of demand, but there's a very big proviso here.
Yes.
You need to look at the terms of your lease agreement. Unfortunately, there are lease agreements that's drafted almost copying the wording of Section 14
yes,
of the CPA, still requiring 20 business days. Now, as long as your lease agreement does allow for you to send a 7-day letter of demand in a situation where Section 14 does not apply, once again, I'm referring to Clause 23 of the TPN leaseback lease, that caters for both situations. So the same contract today could be a fixed term agreement and Section 14 can apply and you need to give 20 business
Correct.
days. Tomorrow, that same contract with the same wording runs on a month-to-month basis. And in that situation, you need to allow in a contract for a 7-day cancellation. But to answer your question, if you're on a leaseback lease, 100%. Month to month, you can send a 7-day letter of demand. However, I would caution you to go back to your lease agreement and ensure that your breach clause doesn't specify 20 business days, regardless of the application of the CPA.
Fantastic.
Okay, then we've had a question from Brenda Joe. So if the tenant has not paid in 20 business days, when you cancel the lease on the 21st business day, when should the tenant move? Oh, sorry. So if the tenant has not paid in 20 business days, when you cancel the lease on the 21st business day, when should the tenant move?
This actually brings us into our next topic of conversation. So what a great question, Michelle. Thank you.
Okay, well then hold that for a mo. Hold that for a mo, because I've got one other one
Perfect.
from Simpiwe Nkobo, who says, why can't we use email or WhatsApp as a letter of demand, as electronic communication is legal in SA?
Wonderful question. So in terms of the TPN lease contract, or in terms of any lease agreement actually in South Africa, you're going to have a clause that is your domicilium or notices clause. This is a clause in your contract that dictates how you must send out formal communication to the parties, whether that's the landlord or the tenant. So it purely depends on your domicilium and notices clause. If you're a TPN Leasepack subscriber, it's your clause 27. And that clause 27 that clause 27 shows us that you can send letters of demand specifically by email. There's no formality, and please help me right here, Sona, there's no formality attached to sending a letter of demand in the manner specifically for a lease agreement, like what you would have with a Section 129 letter in terms of the National Credit Act, if it's for credit industry, or a Section 40 letter in terms of a 41 letter in terms of your Schools Act. But there's no formality attached to that. So you live and die by your contract. That notices and domicilium clause is going to be your most important clause, which is going to say, if you're a TPN Leasepack subscriber, that you can send the correspondence by way of email. Yes.
And Simpiwe, I think I might have confused earlier in the training when I said you can't just send a WhatsApp. By WhatsApp, I mean just a simple WhatsApp saying, hey, you haven't paid, please pay your rent. That's what I mean. If you do have a cell phone number and the parties agree in terms of the agreement, as Peter just rightly said, to potential WhatsApp communication, you can attach that as a PDF. So I'm talking about a quickly typed out thing on your phone. You can definitely attach a PDF on a WhatsApp. You can attach that PDF to an email address. As long as you can show you've dispatched in terms of your notices clause, it's going to be a legal form of communication.
Fantastic. Thanks, Michelle.
Perfect. We've got a bunch of more questions coming in, but I'm going to hold them over now until general, folks.
Perfect. So now we've now discussed a lot on letters of demand, sending the correct letters of demand, cancellation. When can you cancel a lease agreement? What are the time periods allowed for cancellation? When must the tenant vacate? I think that question sort of alluded us very perfectly to this question.
Definitely. Peter, and I think I'm going to start off by boring our audience with a lesson on counting. I kid you not. This is what's going to happen today. Remember, when attorneys start using numbers, then be very scared. Luckily, we have an accountant in the room, so that makes it easier. So, Michelle, if you can just keep an eye on my counting here for me.
I will be auditing it, 100%.
So the reason why counting, and Peter, I know we've done training on this many times, the most important thing is when you start counting your days, and the days I'm talking about now, is the time period you gave in terms of your letter of demand. So let's say Section 14 of the CPA apply to the particular agreement we're talking about now. We need to give 20 business days. Now remember, a business day is every day except for a Saturday, a Sunday, and a public holiday. So it's working days. But working days is a tricky word because some people work on a Saturday. So it's weekdays excluding public holidays, basically. Civil way of counting. We start counting on the second day. So we send a letter of demand today. We don't count today. We start day one tomorrow. Please count on a calendar, guys. I know this is not just an attorney thing. We forget public holidays, and you need to sit and count 1, 2, 3. And remember, then you have months with 30 days, with 31 days, and then you have weird months with 28 or 29, and then you sit with 2 months with 31 next to each other. It's crazy. Use a calendar and count your days out to day 20. Day 20, or day 7 for that matter, is included in civil counting. So you can't send your cancellation letter on day 20. You need to send that cancellation letter on day 21 or day 8. Premature cancellation, Peter, is fatal. Premature cancellation can lead to repudiation. Now, repudiation, I'm sorry to bore you with legal terminology here, but it's very important. Repudiation is defined as a clear communication by one of the parties in a contract that they will no longer be bound to the terms of that agreement. The scary part of this is, if a landlord repudiates, a tenant can accept that repudiation and say, thank you, Mr. Landlord, you told me you're no longer going to be bound by the terms of this agreement, and they claim damages from the landlord. So the defaulting tenant ends up claiming damages from the landlord. Now, this is obviously a very far out thing and doesn't happen in law that often, but the risk is right there. And if your tenant has a clever attorney and they do the right letters, you can end up in a massive heap of problems. So it's a very important thing to be sure that you cancel on the right day. But then you asked, how long do you need to give a tenant to vacate? Immediately. As I said in the beginning of our conversation, once you cancel your lease agreement, that agreement is gone. And only the terms that are supposed to outlive your lease agreement will then be still of force and effect. Now, I just want to brag a little here with drafting on the TPN leaseback lease. In our clause 3, our interpretation clause, we specifically say that some clauses are meant to outlive cancellation. Now, this would be something like the right to claim legal costs, things like that. There's a multitude of things that we still want to apply, but it's very important. Find little nuances. I don't think anybody ever reads the definitions or interpretation clause, but that's actually the coolest part, especially of the leaseback lease. It's my favorite clause, is actually clause 3, so go read that. And once you cancel the agreement, now the tenant is in illegal occupation. If you give him time to vacate, for instance, 10 days, a month, whatever, you create a new right of occupation. The reason why this is scary, we just went through the entire process of 7 or 20 business days to cancel the agreement, just to create a new right of occupation. I really do not recommend that. I know, with, soft beating hearts, we like our yellow sister. We can't probably demand that the guy vacates immediately. Unfortunately, cancel and demand that the tenant vacates immediately. An eviction at this stage does take longer already. So if you're anyway going to take 3 to 4 months to get to an eviction order, where the court will probably order a longer time to vacate still, get to the point of commencing your eviction as quickly as possible. So please, guys, I'm really sort of begging here, don't give time to vacate on cancellation. You need to demand that the tenant vacates immediately. If he doesn't, we can immediately commence eviction proceedings.
Silna, with that cancellation letter that you've now sent out, you've so perfectly summed it up. You've now placed the tenant in illegal occupation.
Yes.
Okay. What happens on illegal occupation? And what is eviction? You've used that term so often now. What is an actual eviction?
It's so interesting that you asked the question. I very often, when I talk about eviction, my definition of eviction is an eviction in terms of law, a legal eviction. Now, for an eviction specialist attorney, eviction can only mean one thing. Eviction can only mean a court order ordering the illegal occupant to vacate. See, now we're not using the term tenant anymore. Now it's an illegal occupant. So an eviction is only a court order demanding that this illegal occupant returns possession of the premises to the rightful owner of the property.
Great. And you can obviously not evict somebody that's not in illegal occupation. So this process that we've just talked about is so vital, because if you get the letter of demand wrong, if you get the cancellation wrong, if you get the counting of the days wrong, you're not going to be placing that tenant in illegal occupation. Yes. Silna, as a simplified flow, would you explain to us a formal eviction procedure? What happens?
Definitely. And I think it's crucial, because if you have the perception that an eviction is simply the sheriff going out with the red hands, locking the building, it sounds very entertaining, but the truth of the matter is that doesn't actually happen that often in rental evictions. Now, there's a vast variety of evictions that we're seeing. Sometimes we do evictions, for instance, in a sale in execution, an insolvency sale where the ownership of the property was removed from the original owner by way of court order. Now, I don't want to talk about those evictions. It's irrelevant for this conversation. Same process, exact same process, but the basis of your illegal occupation is different. Regardless of the reason for illegal occupation, in residential properties, we need to follow the provisions of the Prevention of Illegal Evictions from and Unlawful Occupation of Land Act.
What a mouthful.
Pie. Pie can
Pie
be a
for
mouthful.
today.
Don't take big bites. So pie, let me give you the pie recipe.
Thank you. Perfect.
So on a Wednesday morning. So here's the pie recipe, guys. Get a pen and paper. You need to first, once the occupant is in illegal occupation, most important thing, but I mean, we've spent quite some time on that now. Then you need to get to an attorney. The reason why I say this is I've been presenting the eviction seminar on behalf of the Law Society of South Africa for 10 years now. Yes, don't do calculations then on my age, but I've been training attorneys on doing evictions for years now. And the reason why I know this is not really something that you can do yourself unless there's serious assistance from an attorney is because most attorneys struggle with evictions. Not because it's that complex, but it's very technical in law. The pie recipe is a very fine-tuned recipe. It's like a pavlova. I'm sure anybody can make it from a recipe. I know you did outdoor. I remember you've made one, Michelle. But it's a very technical thing to do. So the recipe looks quite simple, but practically to know exactly what the right temperature is makes it quite tricky. So a correct eviction is actually quite simple. There are only 3 parts to an eviction. You have a notice of motion and a founding affidavit. Now, just quickly, in law, we only have 2 ways of getting to court. On the one hand, you can follow action process. That starts with a summons, and when it gets defended, it ends up in a trial. That is a slower and more costly, very often, process, and we do want to avoid that, especially for an eviction. The other process is motion procedure. That starts with an application. If it's unopposed, you will argue the matter on the unopposed motion roll. The judge will grant your order, or the magistrate, and that is it. If it becomes opposed, however, it stays on paper. What that means is we're not going to have oral evidence. We're not going to have a trial. So it's not going to take that long because it's on paper. And the court decides, have you proved what you had to prove on paper? And it's a much quicker and obviously much more cost-effective process to be on application. So your main application, you ask for an eviction, you ask for a cost order against the illegal occupant, and then you ask for alternative relief, and in certain circumstances, in some areas, you want to also add an interdict, interdicting the illegal occupant from re-entering the premises once they have been evicted by the sheriff. Then part 2 is an ex parte application. Now, ex parte just means one party. So you as the applicant, so the attorney on behalf of the owner of the property, will approach the court and say, can I please have my notice in terms of Section 4.2 of the Prevention of Illegal Evictions Act authorized, and please give me a service directive. What that means is, court, please tell me how I need to tell the sheriff to serve this document so we can show the court and ensure that the illegal occupant got full knowledge of the fact that he's being evicted. And that's it. It's a 3-part thing. It's quite simple, and it gets even simpler. But it's actually, see, the pie recipe is so easy. You need to prove ownership of the property, which is done by way of, we print the Lightstone or Windeed or whatever property search report, there it is. And once you print that, or the TPN report, once you print that, and you can show to a court that this property belongs to you, and that the illegal occupant is in fact in illegal occupation, you will get your eviction order. Now, very important. I'm sorry, I'm going to give you a chance to talk just now, just any moment now. So the most important part is to prove illegal occupation. So I just said proving ownership is quite simple, but proving illegal occupation, you're going to have to attach your lease agreement. This is very important, guys. if you have a handwritten little back of a cigarette pack thing, and I have to go to court with that, the court's going to be like, okay, this is lovely. Even if you have a proper lease agreement, but the court doesn't know the agreement, it causes major issues. Remember, Peter, a judge, just one judge, in just one of our courts on every day, sits with about 75 to 150 matters on the unopposed motion roll. This is massive amount of matters. Those cases are made up from anything, not obviously criminal cases, but it's civil cases with lease agreements, sales agreements, random nothing to do with property agreements. And this judge or magistrate has to know the content of your contract before he can make an order. Now I am bragging blatantly, just because I've been working on the TPN lease back since 2014.
Okay, you've given so much free information today, I think you can.
Can I brag? Can I brag? And we are there where the courts are looking at the TPN leaseback lease, even if it's from one of the national brands and it's beautifully branded with their branding, it doesn't even look like a TPN leaseback lease. The court can look at clause 23 and they pick it out. And they ask us in court, is this contract based on the leaseback? And I am very proud to say that, because basically what happened in courts across South Africa, this is not just Gauteng, not just Western Cape, across Gauteng, across South Africa, we are seeing judges and magistrates recognizing the TPN leaseback lease. The reason why I'm so excited about that is it obviously makes for a much quicker, much more effective eviction order, because the court doesn't have to go and weigh up the reasonableness of the contract, because they know that the TPN leaseback lease is a reasonable and 100% legally compliant contract. So that's pretty cool.
Silma, thank you so much for the wonderful synopsis on evictions. We're obviously going to be sending out that flowchart as well that shows the process that Silma just explained, from your letter of demand right through your sheriff intervention right at the end. But let's talk about the current situation.
Yes.
Because we've now been explaining the perfect eviction, or what would normally happen in court. What's currently busy going on, taking into consideration the alert levels that we've had in the past and what's currently in place for us in the courts?
So let's start by talking about fallacies. So there's this thing out there since the start of lockdown last year, March, this is like way back when, where there was a halt on evictions. But since the 1st of May last year, the 1st of May 2020, we've been able to do evictions, not just obtaining the orders, but also executing our eviction orders. And so we definitely do and can do evictions, not just obtaining the orders, but also executing them. Very exciting. We had a problem, and I think a lot of our viewers might have encountered this. Eviction orders that was granted before March 2020. So before the initial lockdown. The reason why this was a problem is the lockdown regulations does allow for eviction in certain ways and execution for those evictions when a court order to do so. Now, obviously, for us as eviction specialist attorneys, by now it's obvious to add a prayer is the thing you ask the court for. So to ask the court for an order to allow you to execute during the national state of disaster. Now, the problem is the old eviction orders pre-March 2020 obviously didn't have that, because we definitely didn't see that one coming. So nobody had those provisions. Very exciting. We've had quite a few successful applications to court to vary and amend those old orders, and the truth is all of them, well, at least from SSLR, has now been executed in full, which is fantastic news. But what we are currently seeing is we can get our evictions done, we can get them executed, but it takes a bit of nudging and help. We've had quite a few applications to Match Court as well as High Court, where the judge or the magistrate said, but we're in lockdown level 3, 4, or whichever number you are in. Currently we're in 3, but just a few weeks ago we were in 4. So really getting the counting down. But and then the court would be reluctant to grant the order. It takes a bit of not being pushy in court, but you might need to show the court the actual lockdown regulations that does not prohibit evictions. It says that no person may be evicted unless there's a court order after the circumstances has been considered. Now that sounds familiar. That is Section 26 of the Constitution. That's a very old piece of law that we've had. It's just incorporated in our lockdown regulations as well, just once again confirming that we can't evict without a court order.
Process. So incredibly important. Now, you've just spoken about the current scenario with evictions, and like Michelle said in the beginning, it could be a little bit more protracted as a result of the pandemic, as a result of the alert level lockdown regulations. So process is so incredibly vital when it comes to this entire eviction period.
Yes.
From the date of initial breach right through to cancellation, you've got to follow the process, because at the end of the day, if you end up in court and it's now 3 months down the line, you are going to be taking quite a lot longer, even if the eviction is not granted as successful at that point in time, because the correct process has not been followed. Silna, so talking about process, what happens when the incorrect process has been followed? And I know we're sort of getting into very nitty-gritty, dangerous territory over here, but let's move a little bit into spoliation. Landlords or estate agencies perhaps that take the law into their own hands because they see this eviction process as being protracted, taking a lot of time, perhaps costing a lot of money, and they take the law into their own hands. That's not the right way of going, hey?
It's really not.
Not the right way of going
really
about
not.
it. Could you speak to us a little bit about spoliation and what happens in an instance like that?
Definitely, and I think a lot of people actually, because there's this rumor, and I can't call it anything else, that we can't get eviction orders. A lot of people are trying to do lockouts. You know, the old classic, I took the front door off, it's not spoliation, I'm doing maintenance. That is spoliation.
We're only load shedding to your unit by putting the electricity. Okay. Yes.
It's load shedding.
Yes. Doesn't work.
Disconnecting utility supply, any of those things is called spoliation. Now the truth is, it's already been a problem. This is not a new problem. This has already been an issue. And so two reasons why you really should avoid this is, currently, we go to court, it's winter, we have a global pandemic. The illegal occupant stands up in court, the respondent, and he says, but I've been living without electricity and without a front door for 3 months now. Even if everything else was followed correctly, the court is going to frown on that, so much so that the court will probably grant that the people only need to vacate much later. Or even worse, if you haven't followed due process, which very often wouldn't have happened if you do revert to illegal evictions, unfortunately, that could lead to a defense, not necessarily a legal defense. But I think it's very important to point out that just because somebody raises a defense doesn't mean it's going to be successful. What it does mean is now they file an answering affidavit, we now need to file a replying affidavit. The time periods to file these documents for each one of them is 20 court days. This is basically a month. So just that little process is 20 business days. Now, 20 court days for the one, 20 for the other, it's 2 months. What makes it worse, now we need to file heads of argument and obtain a date on the opposed motion roll. If we are in Pretoria High Court currently, opposed motion roll, we will get motion dates around March next year. Just because you've disconnected electricity supply and gave rise to a potential defense that the court might want to listen to. If we in another court, say for instance South Gauteng High Court or Cape Town High Court, opposed motions are quicker, but it's still 6 to 8 months in advance. So something that looked like a quick, let's see if we can motivate the illegal occupant out, is going to be the very thing that drops you from a 3 to 4 month eviction into an 8 months to more than a year eviction.
Silna, thank you so much for that. That brings us to the end of the formal section of our presentation for today. We're going to move over to Q&A that Michelle will be facilitating for us.
Right, so I've tried to put all the questions and answers and group them as we're going along. So seeing as we were speaking on spoliation, let's finish off on spoliation. Metzi has asked, can I lock out a tenant who is in utility arrears for over 5 months and keeps utilizing?
We're going to give a big
No.
head shake over there. Unfortunately, like Silna discussed, the process needs to be followed. And remember, the non-payment of utilities, Silna, is still considered non-payment in terms of the contract. So the same process that needs to be followed for non-payment of your rental needs to be followed in the same way for non-payment of utilities.
Exactly, and if I can jump in, please don't allow a tenant to get to 5 months in arrears on utilities. When can we send that letter of demand? The day following the initial breach. So in the case of utilities, depending on your lease agreement, if you are invoicing with your rent, that has to be paid and cleared in your bank account in terms of the TPN lease pack at least on the first day of the month. So on the second of the month, you already get that letter of demand out. Now it feels silly to send a letter of demand for 150 Rand. Trust me, do it, because 150 Rand has a way of having babies, not just interest-wise, but arrears-wise, because now you get loaded with penalties and interest on top of that. So get that letters of demand out as soon as the tenant is in breach, even when it feels like a silly amount. I promise that amount's going to have babies before you know it.
And practically, of course, putting in prepaid meters does prevent utility costs from accumulating. As we know, this 15% increase in July from Eskom, I don't know how far 150 Rand gets you anymore, Silna.
Exactly, and it's running up. And I think to add to that, if you have an issue with utility supply and your eviction becomes opposed, not because of this connection, because of something else, say for instance the tenant raises another sort of defense. We can approach a court, and we've done this successfully. Actually, fun fact, this was a case we did pro bono with TPN. We tend to do fun things together, the orange and the blue teams. And we actually did the first utility disconnection application on a residential unit in the South Gauteng High Court in 2015. And I think it's very important to keep this in mind. There are ways of stopping the bleeding when it comes to damages that you are suffering while we are busy with the eviction. Just make sure you get to the right firm that actually understands how and when to act with the correct court applications and orders.
Okay, we've got 5 questions that I've grouped into letter of demands. So Imelda's asking, can a letter of demand only be sent from TPN or a lawyer, or can the agency send the letter of demand?
Any person can send a letter of demand. Because the landlord is a party to the contract, the landlord can obviously send the letter of demand. What we've just seen, in Silna, you as well, is that in everyday practice, when you get an external service provider to send a letter of demand, people react to that letter differently than receiving a WhatsApp with a attachment of a letter of demand thereon. So we would suggest sending a letter of demand correctly in the way that the different service providers, whether you're utilizing us, has drafted that letter, formulated that letter, and put that letter into its current format. And the reason for that is you know you're sending the right letter of demand, but the chances that you're going to get a more positive reaction as a result of receiving a letter from an attorney or from a credit bureau or different service provider is probably a lot higher. But any person can send a letter of demand, yes.
But if I may interject just quickly, the wording of that letter is so vital. So just to have it on a specific letterhead does unfortunately not guarantee you a successful cancellation and eviction. Not all letters of demand were created equal, is basically what I'm trying to just throw in, so just make sure it's 100% correct.
Okay, Serena's asking, when a letter of demand is sent and a tenant makes payment, but not the full amount, does the process start all over again?
No. And please, sorry, this is one that usually happens. Please don't send another letter of demand. That was my panic. Yes. Because when you send a new letter of demand, you are starting the process all over. Once again, if you've used the correctly worded letter of demand, it will say that the only way of remedying this breach and getting away from cancellation is to remedy the breach in full. Now, partial payment, even if you short pay by $200, like seriously, that little, you're still in breach, you still haven't remedied the breach, you can cancel and commence eviction. And the fun fact there is, then the tenant basically paid for his own eviction, or at least partially so, because now he paid rent, you accept the rent, you say thank you very much, lovely, we've received it, unfortunately you still failed to remedy your breach, so we're still cancelling, you still owe me that much arrears, and we're going to evict you, thank you very much. I suggest you end that email with a smiley face.
Sonna, this next question from myself perfectly leads into the next question. And in fact, your answer is beautiful. Can, after sending a letter of demand, can you still send emails and other communication to keep the tenant aware of the fact that he or she is in arrears?
100%. Like I just said, just make sure that communication is clear and to the point. I would definitely recommend sending reminders. You are still supposed to be paying. You can still send invoices. Make 100% sure that that invoice doesn't record the rent that is due as rent. It must be recorded as holding over damages. So as long as you make sure you amend your invoices correctly to reflect holding over damages, you can still communicate, but keep it clear. And please don't bring emotions into those. I have to use those letters and emails in court. And if I get answering affidavit with an email from an agent telling the tenant exactly how upset they are with that, it's quite embarrassing. So please remember, all correspondence in situations like that will end up in court, and a judge will read that. So when you communicate, more than welcome to, but keep the judge that's going to read that in mind when you type it.
Right, the next two questions now relate to cancellation. So we've dealt with letter of demands, we're now in the process of cancellation. Sally Ann Williams is asking, do I understand correctly? You sent a letter of demand after 20 business days, and then you wait another 20 business days to cancel the lease agreement?
No. You send a letter of demand giving him 20 business days to remedy. If he doesn't remedy, you cancel on day 21, giving no time to vacate. That will just, as we discussed a little earlier, create a new right of occupation, which is going to cause major issues. Cancel, demand that they vacate immediately, no time required in law for the illegal occupant to then vacate.
So Ronnie's asking a similar question, and I think we can now say it's asked and answered. After 20 business days, you send a notice of immediate cancellation of the lease.
100%.
Perfect. Then
Correct.
we've got some questions from Melissa. She's asking, can we send a policeman or someone to tell the tenant to evict immediately or not?
No.
Please not.
I think that was
I just want to go no.
I think your face and mine no went together. I think that's a clear no. Just quickly on that.
Yeah, please.
I think let's
Very
just
important,
mention criminal law and civil law are worlds apart, actually, to be honest. The police does not have the jurisdiction to evict people. What the police may do is, when the court ordered them to grant assistance to the sheriff of the court to execute an eviction order, then the police may assist the sheriff, but the police's role in that is protection of the sheriff, not execution. The police cannot even execute an eviction court order. Only the sheriff may do that. So if you go to the police, unfortunately, they're just going to say, this is civil, and if you get a polite police officer that might want to help, that's going to drop you in more problems. And the fact that you then with the police doesn't change the position in civil court, unfortunately.
It's almost intimidation and forceful eviction,
Yes.
in a way where you don't have a court order to do so. So very important there.
Yeah.
Don't take the law into your own hands.
Not
If it
even
seems incorrect, it probably is.
Exactly.
Okay, we've got some questions now on lease agreements. So Christine Brits is asking, what happens if you do not have a written lease contract but only a mutual verbal agreement, and the tenant is in default for at least 12 months on residential and business premises?
I think we need to answer that question in sort of a two-phase, if you don't mind. What's currently happening and what will most probably happen in the very near future is that currently lease agreements can be written, they can be verbal, they can tacit. We can do a handshake deal on a residential lease agreement and it's valid and binding between the parties. So that's the current law as it is in place. It's very possible that through the amendment of the laws, through the Rental Housing Amendment Act, that a lease agreement would need to be in writing between the parties to make that contract valid. But as it stands currently, you don't need to have written contracts. Silna, you don't need to have written contracts, but
Please do.
you need to have a written contract. Okay, need is a thing here that sort of surpasses what you want to do. You need to have a written lease agreement in place.
It
because
is
that
suggested because in law it can be verbal. So
it can be verbal.
right now the law stands you can have a verbal lease agreement.
Of course, yes.
But when it comes to disputes, a written lease agreement is going to help both parties.
Exactly, and a verbal agreement is going to lead you to trial and more than a year to get an eviction order on something like this.
Okay, so Bulelo has asked, how do you legally evict a squatting tenant that does not pay rent because the lease agreement is not in their name?
Oh, that's a good one. I do like this. I suppose there could be a lease agreement then with another party, and whether this party is occupying through and under that party is the one option, and we don't know whether that's the case. Or it could be a situation where there was a lease agreement with another party and random person X just started occupying, the other people left, and here they are now. The truth is, if that person does not have a lease agreement with the landlord, by definition that person is in illegal occupation of the premises. The only way he could be in legal occupation is if he has a sublease with the tenant in the current lease agreement. In that situation, obviously somebody's not paying rent, otherwise this probably wouldn't have been a problem. Then you can place the tenant, in terms of the lease agreement, on terms, cancel the agreement and evict him. If that person, reflected as the tenant in terms of the lease agreement, is in fact missing in action, and you can't find him, you have no idea how he is connected to the person in occupation of the premises, you will add both those parties as respondents in an eviction application. You will give the person in occupation notice to say, listen, I don't have a contract with you. You have X amount of time to vacate the premises, or to even conclude an agreement with the landlord, if that's what the landlord wants. Conclude a new agreement, but that's obviously not the question. And then proceed with eviction of both the tenant in terms of the lease agreement, for in case he does return at some stage or pop out of the woodwork when we're busy with the eviction, as well as then the illegal occupant that doesn't have a contract with the landlord.
Staying in lease agreements, Isel has asked, if we have a TPN lease, do we need new updates for, do we need new updated ones for the new POPI clauses? And I imagine that may refer to two things. One, signing of new agreements, but two, for the tenants that are already in occupation, do those lease agreements now need to be re-signed?
So what TPN has done over the last 6 months is we've updated our lease agreements, the sale documents, commercial and residential, with POPI clauses in the regulatory compliance clause in all of those agreements. Now, they're the POPI clauses that allow for processing of personal information, etc. But because the landlord is a party to the actual contract, those POPI conditions in terms of Section 11 will already be applicable. So you can still process the personal information in terms of your lease contract. So you shouldn't be signing new lease agreements with new tenants during the lease period. What we would suggest is on renewal, signing new documentation. Don't just do an addendum to the contract here, sign a new agreement so that you get those regulatory compliance clauses that is binding both parties for data protection in terms of those contracts.
And the truth is, that's not just for POPI, it's for everything else. We meet every 2 months to discuss the content of the leaseback lease. And we very often move a comma here and add a full stop there, or add a word and remove a word. It's nothing spectacular, but it's so crucial. So always ensure that you use the most recent agreement when you are signing a new agreements. And obviously, if you move from one agreement and you are moving to say, for instance, the TPN leaseback lease, please then make sure every time you sign the most recent version of the leaseback, so you know you are covered in every single aspect that we know how to.
The next two questions now relate to DigiSign, Peter, and this is a term that not all of our clients are going to know. So let's talk about DigiSign very, very, very quickly because we've got 6 minutes left and there are still more questions. Fulna and Simpiwe both have questions. So Fulna's question is, we had applicants who complete the rental application and then we prepare the lease and do the credit checks, and then they do not take it up. What recourse do we have if they refuse to pay the contract fee? That's question number one. And question number two, Simpiwe is asking, what if a tenant was sent the lease agreement but does not return the signed copy but continues to pay the rent according to the lease terms? What document do you now use to the initial lease cancellation or eviction?
Okay, so obviously question in two spaces here. So now I'm going to take the first one, then I'm going to pass on to you for the second. When the lease agreement, and I'm hopefully getting this right, is the lease agreement is unsigned by the tenant and unsigned by the landlord. Remember, at that point in time, you've purely got a hope of an agreement being entered into between the parties, sorry. Both parties need to sign the contract, or at least there needs to be agreement reached between the parties before a contract can come into existence. So if the tenant has promised the world, and promised the world over email, and promised the world over the telephone, and telling you he's going to make payment of this and that and the other, remember, the contract is the most important thing. So the contract and getting that signed and accepted between the parties, you don't have an agreement yet until that has happened. So you've got that hope of the agreement entered into. So now the next question, obviously, if the agreement has not been signed by the tenant, what happens there?
Well, luckily we have Regulation 4 of the Unfair Practice Regulations. So Regulation 4 of the Unfair Practice Regulations to the Rental Housing Act says, even if the contract wasn't signed by the tenant, but he took occupation and he paid rent, the contract is deemed to have been fully signed and delivered to the other party. Same goes for the landlord. When the landlord accepts rent and gives occupation, the contract is then seen as if it was signed in full and delivered to the other party, meaning that all rights and obligations in terms of that contract, even though it's unsigned, will be fully enforceable against both parties.
Correct. So you could still send a letter of demand for non-payment of the deposit if the contract's in place. Good.
Okay, we're now going to talk about regulation. Heidi wants to know what would happen if there are children under 13 living in the property with their parents, I imagine during the eviction process.
Yes, so the Prevention of Illegal Evictions Act gives us 4 equity groups. So it's elderly people, women-headed households, minor children, and disabled people. What the Act says about this is we need to bring this to the court's attention so we can enable the court to make an order of when they need to vacate that is just and equitable. There is also a fallacy out there saying that if you have one of these equity group occupants in the property, that you would not be able to evict them. That's luckily completely untrue. We simply tell the court, this is the position, this is the person's disability, or this is the number of minor children, this is their age, and obviously anybody under 18 is minor. We tell the court about that, and the court uses that information to determine a date that would be just and equitable to have them evicted.
Okay, we've got another question regarding the Rental Housing Act from Loretta. Does the Rental Housing Act provision that a calendar month notice be given to the tenant to vacate not apply?
A calendar month's notice, most probably not in the instance where it's a fixed term contract. So remember, there's a difference over there. A calendar month's notice, whereby either party can provide one or the other with a calendar month's notice, is in terms actually of the Rental Housing Act and the Consumer Protection Act, but that's only on contracts that reach that month-to-month basis after the initial period, or if you enter into a lease agreement from the initial instance, that's on a month-to-month basis. Yes, still applicable, but that's only with contracts that are on a month-to-month basis between the parties.
And that's very much about the difference between termination and cancellation. Remember, that month's notice to end a month-to-month agreement isn't cancellation, that is termination, because nothing bad happened. Nobody is in breach of the agreement. It's a month-to-month agreement that's not going to end by itself. You need to give a month's notice that it will in fact terminate. Cancellation is an act on breach, and cancellation never ever works on a month's notice. It's either 7 or 14 or whatever amount of days that your contract allows for. If it's silent and verbal, it's 7 days in terms of the Rental Housing Act. But if it's a fixed term agreement and Section 14 of the CPA apply, it's still not a month's notice, it's 20 business days notice.
Last few questions. We've got a question on arrear rental judgments. Giselle's asking, how do we deal with a tenant who did not pay his full rent and no longer stays in the unit but has left all of his belongings behind?
Silna, you've got this one from the legal side.
Good, my little dance, that's my favorite. We can't just take stuff. I know about the landlord's hypothec, and that means that all the items brought onto the premises by the tenant or even a third party brought onto the rental premises can be attached in lieu of arrear rental. That attachment doesn't mean you go with a truck and you take it and yay, now you have a vase and a couch. It means you need to approach a court for an order to do that. And importantly, in a situation like this, somebody owes rent and there's stuff left on the premises, my recommendation would be to do a rent interdict summons, go to an attorney, do a rent interdict summons, get the sheriff to attach those items, and then once you have the court order, you can sell. You can also utilize the Section 32 of the Magistrates Court Act to approach a court on a quicker basis to attach those items and then have it sold by sheriff. Better idea, to be honest, slightly more pragmatic here, but that's my answers usually, would be to do a notice to the tenant to say, Mr. Tenant, and please don't do this yourself. This is where you get an attorney that actually knows exactly how this works to do it. Where you do a notice and you say, Mr. Tenant, you forgot your stuff. Are you going to come and fetch it? If not, I am going to move it into storage, and you can then proceed with the attachment and sale once you have a judgment. Unfortunately, you can't just take it and sell it on OLX and hope for the best there.
From a credit bureau perspective, also remember that you can still submit the payment profile information directly into TPN, as well as possibly blacklisting that tenant if the 3 months in arrears and the correct letters of demand has been sent. So follow the court process, just like Silna spoke to you about that, but in parallel, you can also obviously follow the credit bureau process as well.
Okay, now on to eviction costs. Butu wants to know, what is the cost of getting an eviction order, Silna?
Oh, that's beautiful. And if you asked me this question about 3 years ago, I would have said, how long is a piece of rope, or some silly question. I can really answer that. We as SSLR have done, we broke an eviction, a residential eviction, up into 5 phases. And we charge either itemized billing, like in the old days, when you pay for each email or each telephone call and what. Or you can opt for a phased billing approach, and you know exactly what you're going to pay. You pay up front for the phase, we finalize the phase, and before we go to the next phase, you pay the rest. I'm actually quite sure our fee schedule is on our website. If it's not, you are more than welcome to pop us a mail through our website. Well, I share that fee schedule like it's nobody's business. Everybody is allowed to see it, and eviction's going to end up unopposed, costing you between 35 and 40,000 Rand. The about is the sheriff cost. I can't control what the sheriff is charging. I can control what SSLR is billing. So between 35 and 40,000 Rand. When it becomes opposed, it's obviously more expensive, and then you're looking at around 60 to 65,000 Rand. Once again, with the sheriff cost there of the actual eviction outside of that number, because if it's an eviction where I need to bring in external security, for instance, the Red Ants or a company like that, it will unfortunately be more expensive. Even though it looks expensive, remember, you are not considering your eviction cost based on the arrear rental. It's the value of your property. And you need that property back as quickly as possible. So that is typically the cost that you're going to look at. But for more details, you're more than welcome to visit our website on process and cost. We are one of the open, share exactly what we charge firms.
So this is an important question. It's one that I wanted to end on, but I have another one after that. The question that I wanted to end on was from Hillian. Can we please get Silna's contact details, so your website address and a generic email address for the firm, please?
Yes, definitely. So it's www.sslr.co.za.
And we'll put that up on the screen.
Brilliant,
as well.
thank you. Especially that SSLR. Sometimes my Afrikaans R doesn't roll properly. And you are more than welcome to email us. I think to make life easier, I'm going to give you the email address for our client liaison officer, which is Lisa. Lisa is simpler to spell than Silna. It's Lisa, Lisa, at sslr.co.za, and Lisa will put you in contact, either answer your questions or put you in contact with an attorney you are more than welcome to discuss anything with. We actually are one of the few firms that will accept questions and just give you a quick answer without billing you. We actually bill only for actual work and will quote you upfront before we start.
Fantastic. And then the question that we're going to end on is from Sharon. If you've already started the eviction process through an attorney and the tenant continues to occupy, how do we recoup the rental for those months?
Okay, so Silna's already discussed the possibilities of running parallel applications or with a rent interdict summons during the same point in time as the eviction. Obviously, from the Credit Bureau, you can also submit the payment profile information directly through TPN, through your property management system, or manually, as well as being able to blacklist should the tenant be 3 consecutive billing cycles in arrears and you having sent the correct letter of demand. And you can run that process completely parallel. So together with the eviction, you can still go through the Section 32 application as well as the rent interdict summons and the Credit Bureau action as well.
And the reason for the look we gave each other here is I am very reluctant to spend a lot of money on legal fees when it comes to collection. You spend your money on legal fees at the right place, and in my head that is 100% the eviction. A proper quick eviction is going to cost you a bit of money, but to spend money on an attorney to go and collect the rent, regardless of the amount, you do have the right as the landlord, or when mandated and paid for it by the agent, to approach the Rental Housing Act, the Rental Housing Tribunal on behalf of the landlord. Please don't do it for free agents. You are entitled to remuneration for that. To approach the Rental Housing Tribunal, an order from the tribunal is worth exactly the same as the magistrate's court. So when you then come to us with an eviction, with an order for a rear rental from the tribunal, we can simply issue that through Mag Court. On that, I need to just mention, the tribunal does not have the jurisdiction to grant an eviction order. Eviction must be done through court, but your rental collection, depending on the amount, seriously residential, consider rather obtaining that order through the tribunal. But like Peter said, it can be done concurrently at the same time.
Silna, just a final golden nugget from you. I know my takeaway from today's session, and it's the one that I always share. Start the process as quickly as possible. Yes. Your golden nugget for today?
My golden nugget for today is start the process as quickly as possible, but please, please, please use the correct documentation. From your lease agreement to your letter of demand to your cancellation letter, please, there's some things that we DIY, but this is not one of them. Please make sure you use the correct documentation.
Thank you very much, Silna. Thank you, Michelle. Yeah. The feedback forms are now being placed in the Q&A as well. Please go and complete those for us, not just important for ourselves, but for your unverified CPD points as well. We're going to be sharing that eviction flowchart with you from Silna. Everybody have a fantastic day further and can't wait to see you again.